A 4-month prison sentence is a sunk cost that can never be recovered, but a vacated conviction is a total forensic rewrite of the historical ledger that effectively liquidates the legacy of the January 6th committee. We are witnessing a post-closing adjustment of the highest order, where the Supreme Court has signaled that the criminal prosecution of a private citizen for defying a congressional subpoena was a material misstatement of constitutional authority. While the media focuses on the symbolic nature of the victory, we are performing a forensic reconciliation of the separation of powers to see if the internal controls of the federal government have been permanently restructured to protect the human capital of an incoming administration. I am Camilo Motado, and this is Camilo's House. As a certified public accountant focused on forensic verification, I don't follow the headlines. I perform a systematic audit of the power structures that govern our republic. In a standard financial audit, if you find that a regulatory body exceeded its authorized mandate to penalize a consultant, you don't just record the error. You perform a systemic review of the operating agreement. Today, we are auditing the Supreme Court's order to vacate the contempt conviction of Steve Bannon. We are analyzing a scenario where the Department of Justice has issued a management override of its previous findings, declaring that the prosecution was no longer in the interests of justice. This is the contempt liquidation audit, and we are documenting the moment where the subpoena power of the House was found to be reputationally insolvent. The operational trigger for this SCOTUS intervention is a brief unanimous order issued on April 6, 2026, that throws out the appellate ruling upholding Bannon's 2022 conviction. From an investigative standpoint, the materiality of this case is unique because the penalty has already been fully paid. Bannon spent 120 days in a federal correctional institution in Connecticut, a non-recoverable asset of his time and freedom. However, in the world of forensic politics, the historical record is the most valuable intangible asset a brand possesses. By vacating the conviction, the Supreme Court is scrubbing the liability from Bannon's permanent file. It allows a trial judge to act on the DOJ's pending request to dismiss the indictment with prejudice, effectively wiping the slate clean and treating the entire 2022 jury verdict as a voided transaction. To understand the forensic logic behind this reversal, we have to audit the ideological pivot of the Department of Justice. Under the previous administration, the DOJ's internal auditors viewed Bannon's refusal to testify as a systemic breach of the House's oversight function. They argued that because Bannon was fired from the White House in 2017, his executive privilege protections had expired. But as a CPA, I track the continuity of relationship. Bannon's defense was built on the goodwill of a consultative partnership with the president. His attorneys argued that the separation of powers creates a sovereign shield that protects the strategic communications of a president, regardless of the official payroll status of the advisor. The Supreme Court's decision to vacate the ruling suggests that the standard operating procedure for willful contempt was misapplied by the lower courts. The Sittenfeld parallel provides additional forensic evidence of a broad market correction. The justices issued a similar order for former Cincinnati councilman P.G. Sittenfeld, who was convicted of bribery but later saw the underlying legal landscape shift. By linking these legacy liabilities, the court is signaling a massive write-down of the prosecutions initiated during the previous audit cycle. It is a regulatory signal that the aggressive oversight of the 2021-2024 period is being reviewed for compliance with fundamental constitutional principles. For Bannon, this is a reputational recapitalization. His war room brand, which suffered a temporary impairment during his incarceration, is now being valued at a premium as a vindicated asset of the MAGA movement. We must also audit the information asymmetry surrounding the term willfully. In the original trial, the reporting standard used by the court was that willfully not complying with a subpoena was synonymous with intentionally not complying. Bannon's defense argued this was a material misstatement of the law. They contended that he was following professional advice from his attorneys, a standard of care that should have mitigated the liability of his defiance. By vacating the lower court's ruling, SCOTUS is opening the door for a new valuation of what it means to willfully ignore Congress. If advice of counsel becomes a valid internal control, the cost of contempt for future executive branch consultants will drop to near zero, effectively deregulating the House's ability to audit the executive. The state-level accounts in New York remain a separate ledger that this SCOTUS order cannot reach. Steve Bannon recently pleaded guilty to defrauding donors in a state-level prosecution related to the Build the Wall initiative. From a forensic accounting perspective, this is a fragmented liability. While his federal credit score is being restored by the Supreme Court, his state-level reputation is still impaired by a plea deal that allowed him to avoid additional jail time. This cross-jurisdictional variance proves that in the high volatility market of American politics, you can be solvent in DC and bankrupt in Manhattan simultaneously. The Build the Wall case remains a legacy debt that Bannon must carry on his social balance sheet. The strategic risk to the Jan 6 committee's findings is perhaps the most significant audit finding of the week. The committee was designed as a special purpose vehicle to investigate the operational failures of the 2021 Capitol riot. By successfully convicting Bannon and Peter Navarro of contempt, the committee certified its own subpoena power. But now that the executive branch management has changed, those certifications are being rescinded. The DOJ's new prosecutorial discretion is being used to cancel the contract of the Jan 6 prosecutions. It is a hostile takeover of the narrative, where the auditors of the riot are now being audited for bias by the new management team at the Justice Department. As a CPA, I look at the amortization of punishment. Bannon has already paid the interest on his contempt debt by serving 120 days. The dismissal of the conviction now acts as a return of capital. It restores his voter registration rights, his professional standing, and his legal status. But the social equity of the rule of law is what suffers a systemic devaluation. If a management change at the DOJ can liquidate a jury conviction that was already affirmed by an appeals court, then the finality of the legal audit is a material misstatement. It tells the market that criminal liabilities are temporary and subject to political revaluation. My forensic verdict on the Steve Bannon SCOTUS win is that we are witnessing a systemic realignment of the constitutional balance sheet. The contempt of Congress ledger has been voided because the incoming management viewed the original transaction as a political overreach. While Bannon's war room infrastructure celebrates a symbolic recovery, the infrastructure of congressional oversight has entered a state of technical insolvency. If the House cannot enforce its subpoenas without the Auditor General agreeing to the valuation of the crime, then oversight is no longer a mandatory control. It is an optional disclosure. The interests of justice cited by the Trump DOJ is the ultimate management override. It allows the executive branch to pardon through procedure rather than pardon through decree. By asking the courts to dismiss the indictment rather than waiting for a presidential pardon, the administration is attempting to audit the past into non-existence. Steve Bannon's 4 months in prison will remain a historical variance, but his criminal record is about to be reconciled to a zero balance. I want to hear from you. Is the symbolic dismissal of a conviction after the sentence is served a correction of an error or a material breach of accountability? Does the management change at the DOJ prove that the legal ledger is always subject to political depreciation? Let me know in the comments. Your perspective is the only audit that matters when the separation of powers and the integrity of the subpoena are sitting on the negotiation table. I am Camilo Motado, and this is Camilo's House. Subscribe to stay informed on the numbers, the laws, and the truth behind the headlines. Stay safe.